Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to the KNL Gates podcast series, where we look at trends in international arbitration in different regions. In this podcast, we will be interviewing Mr. Vivekananda Neelakantan, Registrar of the Singapore International Arbitration Centre, the SIAC, or we also call them SIAC. My name is Joan Lim-Casanova, a partner from the Singapore office and part of the International Arbitration Group. This is a two-part podcast whereby in the first, we will talk about the key features of arbitration under the SIAC rules, and in the second, we will talk about the trends in international arbitration in Singapore, Asia, and beyond.
This podcast is limited in scope as appropriate for a general audience and the applicable time constraints. The information in this podcast is not offered as legal advice, which should be obtained from properly licensed legal professionals on the basis of the specific facts of a given case. All speakers appear in their personal capacity, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the views of KNL Gates Straits Law, KNL Gates LLP, or any other entity or individual. So Vivek, London and Singapore are the top two most popular arbitral seats, with London at 34%, Singapore at 31%. And the other more popular ones are Hong Kong, Beijing, and Paris. And this was from a pretty recent survey by Queen Mary School of International Arbitration. Can you kick off by sharing with us what's the structure of the Singapore International Arbitration Centre, and how did SIAC contribute to Singapore as a preferred arbitral seat?
Thank you, Joan. It's my pleasure to be here on this esteemed podcast with you to share my thoughts on SIAC today. As many arbitration users and contract drafters will know, the concept of a seat of arbitration is, of course, extremely important to how disputes come to be resolved by way of arbitration. And Singapore today certainly is one of the most popular choices for a seat of arbitration globally and certainly in the Asian region. And that is really because of a concerted effort, I would say, over the last 20 odd years by all of the stakeholders that have been part of the arbitration ecosystem in Singapore. And that involves, of course, the Singapore government, who has been quick to respond with changes when necessary to the legislations that govern arbitration in Singapore. The Singapore courts have long been recognized as arbitration friendly in the form of the decisions that they have issued regularly, which have shown consistently that they are willing to enforce arbitration awards and arbitration agreements. And they rarely intervene in the process of an arbitration and in respect of challenges to awards, except in certain exceptional situations. Now, the SIAC, of course, is the preeminent institution that is based in Singapore. But today, I think it is fair to say that we have fairly global appeal across a wide range of users from around the world. The SIAC, of course, is led by its board of directors and the Court of Arbitration. The board of directors is led by Mr. Devinder Singh, senior counsel, who is the chairman. And the Court of Arbitration comprises almost 40 practitioners and international arbitrators from around the world who are experts in their own right and very experienced in the field of international arbitration. The Court of Arbitration is, of course, headed by the president, Ms. Lucy Reed, who's based out of New York in the US. And as you know, I myself head the secretariat, which is the team that manages and runs the cases at SIAC on a day-to-day basis. That is, of course, the general structure of the SIAC. And I'm quite happy to talk about the various developments that we have seen in this space of international arbitration. Singapore as a seat is, of course, something that we commonly observe in our cases at SIAC. And it stands to reason that many parties feel comfortable choosing Singapore as their seat of arbitration for the reasons that I mentioned, quite apart from the fact that we are based in Singapore?
Yes, so I've been traveling regionally since my work brings me to other Southeast Asian countries and also quite a bit to China. And the feedback to me is that in terms of the dispute resolution clause, SIAC is commonly used and a lot of times is not even negotiated anymore. And I'm getting common feedback from the partners in Japan and Korea as well. So can you now tell us a bit about the new rules of SIAC that just came into effect in January this year? What are the new features and what were the drivers for those changes?
As you know, we are a relatively young international arbitral institution. We are only about 34 years old. But I think in this period, we've grown a fair amount and seen a number of cases over the years. And just to give your listeners a sense of that growth, in the year 1991, when the SIAC was first established, we only received 2 cases. In 2001, that number was 64 cases. And in 2021, it grew to 469 new cases that we received that year. Last year, in 2024, we received 625 new cases with a total sum in dispute of about USD 12 billion and an average sum in dispute of about USD $19 million. In the same year, 2024, we handled cases from parties from 72 different countries globally. And in the last 5 years, that has included parties from over 100 different countries around the world. Now, as an arbitral institution that caters to a wide variety of users, we've been quite conscious about 2 aspects. One is our user interface, and the second is our software. And what do I mean by that? The user interface is our secretariat, which is the team, like I said ahead, which is the team of lawyers that administers and manages cases at SIAC. We currently have 17 lawyers in the team with 12 different nationalities and qualified in as many jurisdictions. And the spread of experience and expertise gives us the ability to cater to the specific needs of our wide user base and provide them with the comfort of arbitrating international disputes. On the other hand, the software is the rules pursuant to which arbitrations are administered by SIAC. The latest version of the rules, as you said, are the 2025 SIAC rules, which came into effect on the 1st of January 2025. This is the 7th edition of the rules, and there have been 6 editions before this. And over the years, there's been a conscious effort at the institution to include provisions in the rules that are intended to provide tools, if I may call it that, to parties and tribunals to achieve efficiency in the process and secure the enforceability of any award that is made in the arbitration. Now, towards this end, as many will be aware, in 2010, we were amongst the first institutions to introduce an expedited procedure process, which is essentially a fast-track arbitration procedure, which allows you to complete your arbitration within 6 months from the constitution of the tribunal. And it is applied when parties apply to use the procedure on the basis of certain criteria. Currently, that is based on a monetary threshold of Singapore dollars 10 million, or the equivalent of US dollars 7.5 million. And if your sum in dispute is less than that and above US dollars 750,000, parties can apply to use this procedure under our rules. Over the last 15 years, we have received more than 1,000 applications for this procedure, and about 60% of them have been accepted. And therefore, we have had substantial experience running cases under the expedited procedure, which are cases that are completed in the 6-month time frame. What, of course, is useful for is cases that are not unduly complex and can be completed in that time frame. In that same set of rules in 2010, we also introduced the emergency arbitrator provisions, which are a means to request the appointment of an emergency arbitrator to consider and rule on requests for urgent interim relief. And as we know the nature of disputes, the fight for interim relief is often the most crucial fight in many of these disputes. And consequently, the emergency arbitrator provisions have also proved to be very popular. On average, I think at SIAC, we receive a new request once every 2 weeks to request the appointment of an emergency arbitrator. In 2014, we introduced the ARB-MEDA protocol, which is a protocol that parties can sign on to either in their contracts or subsequently, and provides for a tiered dispute resolution process whereby you commence arbitration at SIAC and the arbitration is stayed for a period of time to allow parties to attempt mediation at the Singapore International Mediation Center. And if the mediation is successful, parties can come back to request a consent award, or they can simply terminate the arbitration. If the mediation is unsuccessful, in whole or in part, parties can simply come back and resume the arbitration. And this is again a process that we find parties like very much as a tiered dispute resolution process. Then in 2016, we introduced a procedure for the early dismissal of claims and defenses, where such claims and defenses are manifestly without legal merit or manifestly outside the tribunal's jurisdiction, and which really allows parties to knock out discrete claims and defenses if they are completely or manifestly without legal merit. Similarly, at the same time, we introduced provisions for multi-party, multi-contract disputes, for the consolidation of multi-contract arbitrations, or for the joinder of parties to arbitration. So in that same vein, in the 2025 rules, there are further new procedures, which are, as I like to call it, efficiency tools, so to speak. First and foremost, we introduced the streamlined procedure, which is essentially a further fast-track procedure, which allows for an arbitration to be completed in 3 months from the constitution of the tribunal. And this applies automatically in cases where the sum in dispute is less than 1 million Singapore dollars, or the equivalent of $750,000 US roughly. And parties can, of course, apply to the SIAC, and the president will decide if parties do not wish that procedure to apply in a particular case. Parties can, of course, also agree in their contract or post-dispute to apply the streamlined procedure. Now, the interesting thing about the streamlined procedure, the way it is formulated in the rule, is that as a default, the cases are meant to be decided by the tribunal on the basis of submissions and documents only, and there is to be no document production or no fact and expert witness evidence, and no hearing, unless, of course, the tribunal determines otherwise, that any of these stages are required on the basis of a request by the parties. And that really is our marker or a cue to tribunals and parties to consider quite carefully the need for these stages in international arbitration as we've come to accept them, particularly for cases that are low in value and low in complexity. And to make that procedure even more attractive, there is a discount that is applicable to the tribunal's fees and SIAC's fees. So the fees for a streamlined procedure case is set at 50% of what the normal fee caps would be under the SIAC schedule of fees for the tribunals and SIAC's fees. The further addition we made in the 25 rules was to include a mechanism to ask for an emergency arbitrator to be appointed without notice to a counterparty. So essentially seeking the appointment ex parte, which is a completely new process, which is in addition to the existing emergency arbitrator mechanism. And the purpose is simply to seek a preliminary order from the emergency arbitrator to ensure that the interim relief that is sought is not frustrated. And this is in recognition of the fact that there may be certain fact situations where it is necessary for parties to apply for that preliminary order on an ex parte basis. And the rules, of course, contain various checks and balances to ensure that counterparties are provided notice shortly after such a preliminary order is made or considered. The requirement actually is that they be notified within 12 hours after the Secretariat transmits the file. In any event, if a counterparty is not notified, the preliminary order expires within 3 days, and the entire process in any event takes 14 days for the emergency arbitrator to consider the request. The last one I will mention is the new provision added in for preliminary determination of issues, which was added into the 2025 rules. And this again is in recognition of the fact that very often there are issues in international arbitration of a list of issues that may be created by a tribunal and parties that can be dealt with on a discrete basis and may be dispositive of some claims that arise in the arbitration. And it is our cue to tribunals and parties to say you should consider whether there are specific issues that can be dealt with on an early preliminary basis, which may be contributing ultimately to the efficiency of the process. Of course, these are all tools in the armory that are available to parties and tribunals to deploy as they see fit. In addition, of course, there are a number of tweaks to the process of case administration based really on our experience of administering thousands of cases over the last several years. And those are provisions which are perhaps more nuanced and really reflect, I think, improvement in case administration and case management processes.
Yeah, I like how you called them the efficiency toolkit, because it's very helpful when us as practitioners, when we advise clients, all clients want the most cost-efficient manner to resolve the dispute in using the fastest amount of time and the least cost possible. When SIAC thought about enhancing the tools or adding more tools into this toolkit, how do you guys go about gathering the feedback? For example, the streamlined procedure, which is new, introduced this year for disputes under 1 million Singapore dollars or 750,000 US dollars. What was the process in which you went about gathering feedback and implementing such changes?
I think there are two aspects to it. One is, I think, what you very rightly said, as what the main considerations are for parties in international disputes. And I think there are broadly 4 questions perhaps that any party is asking in an international dispute is, how much is this going to cost me? How long is it going to take? Am I going to be, party to a fair process? And am I going to have an enforceable award at the end of that process? So I think for us as an institution, anything we have put into the rules, our processes of case management and administration are really driven by a keenness to answer those questions. And I think much of what you see in the rules, including, for instance, a very specific rule that says and sets out the objectives with which tribunals and parties should approach international arbitration, which are the 4 things that I mentioned, has always been, I think, the ethos at SIAC is to try and answer those questions. And much of what I described about in terms of the procedures and processes is driven by that. More specifically, in respect of the streamlined procedure, that is also, I think, driven by the understanding that a number of claims are today perhaps not brought to international arbitration because of the perceptions surrounding time and cost. And very often, small value claims don't get brought to arbitration in the form of even a case being commenced because of the perception that it is simply not worth it. And I think it was our way of providing a mechanism and an answer to that question to say, you can in fact arbitrate these kinds of claims, and we can make it worthwhile by way of ensuring that the time and cost is manageable for parties to be able to bring those claims to arbitration. And that really was the thinking behind the streamlined procedure. And as you know, Joan, we released a consultation draft of the new rules about 2 years ago or 1.5 years ago, and went through a fairly extensive public consultation exercise with practitioners and users over a number of months. And I think that exercise also taught us that the reception to such a proposal was very positive, and it was much appreciated by, I think, the user base to say that this is a procedure that will be used and will be useful to end users at the end of the day, and it's much appreciated. And I think that informed us that we were headed in the right direction and therefore it found its way into the final set of rules.
Yeah, certainly. We had feedback in the past that, is arbitration only for the big multinational companies? How about the small, medium enterprises where the quantum in dispute, usually a couple of hundreds of thousands, is arbitration or some kind of what they know as summary judgment available in arbitration, and now we're able to tell them about the streamlined procedure.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.